As we learn about civil liberties and civil rights, it can be a bit confusing to remember the difference between the two, especially since they have similar meaning and are often used interchangeably. Both civil liberties and civil rights are rights, but they refer to two different categories of rights, derived from two different sets of constitutional amendments, ratified nearly a century apart. When we refer to civil rights today, we are typically referring to those that flow from the constitutional amendments that were passed immediately following the Civil War, the 13th, 14th, and 15th Amendments. But in this video, we are going to focus on civil liberties, which, constitutionally speaking, have been around much longer. You might recall that about half the delegates to the Constitutional Convention in 1787 feared a government that had too much power. So they agreed to add a Bill of Rights to the Constitution right away, which contains the first 10 amendments, and it was ratified in 1791. Even though the Bill of Rights clearly contains rights, after all, it is the Bill of Rights, not the Bill of Liberties, these first 10 amendments outline what the national government may not do to infringe upon our civil liberties. The Bill of Rights restrained the federal government from infringing upon particular liberties. You can think of the Bill of Rights as a bill of restraint on the government so that people could retain the greatest amount of freedom from government interference on their lives, their liberty, their pursuit of property, and ultimately, their happiness. Like the rest of the Constitution, the Bill of Rights was rather brief and perhaps not as specific as some would have liked, leaving plenty of room for future interpretation. It is so brief, in fact, that this 8x10 slide shows the Bill of Rights in its entirety. So let's take a relatively brief peek at the Bill of Rights and how the civil liberties contained within it are interpreted by today's legal standards. I like to look at the main body of the Constitution as the document that provides the powers of the national government. And in doing so, they kind of define a basic framework for the structure of the government. While the Bill of Rights didn't provide powers to the government, it placed restraints and limits on the government and what the government could do to infringe upon certain freedoms held by the people. I once had an insightful student share that she looked at the Bill of Rights as the fine print to the Constitution, similar to the restrictions that are placed at the bottom of a coupon in fine print. At the Constitutional Convention, there were delegates like George Mason from Virginia who wanted to include civil liberties that prevented the new government from having too much power, but he wanted to do it inside the actual body of the Constitution. But delegates like Alexander Hamilton from New York believed that the body of the Constitution should be limited to outlining the powers of the government. Hamilton thought that including limitations on the government within the very document that gave it power, the body, would significantly weaken the authority of such government. So both sides made their arguments and determined what they could live without, ending in a compromise that made it possible to move forward with the body of the Constitution as the primary source for outlining the powers of the new national government, as well as a document to serve as an addendum. And this addendum would be what we now know as the Bill of Rights, outlining the Constitution's limitations in the form of several amendments. At first, there were 17 amendments that were adopted by the House of Representatives, and then the Senate agreed to 12 of them. But only 10 of them were ratified by the required number of states, and on December 15th, 1791, the Bill of Rights was adopted as part of the Constitution. And the very first words of the very first amendment do not beat around the bush in making the purpose of this document crystal clear. It begins, "Congress shall make no law." Now, this is a good way to remember that the Bill of Rights is what tells us what cannot be done by the federal government right away. It's saying what the government cannot do. Congress shall make no law. And as we go through the amendments in this summary, I want you to think about each of them and how they place some kind of limitation on the government's power. Some, like the first few, are obvious, but later amendments require a little thought to think through what exactly they are prohibiting or limiting, and why the civil liberties in the Bill of Rights are rights, but they are rights that are created by prohibiting the government from doing something rather than rights that say that the government has to provide something. The First Amendment prohibits the national government from forming a church and infringing upon the free exercise of one's religion. It also prohibits the federal government from infringing upon the freedom of expression through speech, through a free press, and the right to peaceably assemble. The Second Amendment prohibits the government from infringing upon the right of the people to keep and bear arms. The Third Amendment prohibits the federal government from making you allow soldiers to stay in your house unless they first make a law making that legal. The Fourth Amendment prohibits the federal government from violating your privacy in certain ways, like unreasonable search and seizure of your property without a warrant obtained with probable cause. Now, a little caveat here. Amendments 4, 5, 6, and 8 all have to do with prisoners or the rights of those accused of a crime. Why so much of this? Well, as we learned in earlier lectures, one of the chief complaints the colonists had while living under British rule was wrongful adjudication of crimes. The United States was founded following an age of political enlightenment in which many political philosophers believed that a nation's moral fortitude could be judged by the way it treated those accused of a crime. The Fifth Amendment prohibits the federal government from denying certain legal rights to people who've been accused of a crime, like prohibiting the government from trying someone twice for the same crime or double jeopardy, or compelling someone to testify against him or herself, or depriving people of life, liberty, or property without due process of law, and from taking property from you without reasonable compensation. The Sixth Amendment prohibits the government from arresting people for crimes without telling them why, from denying the assistance of counsel, and from denying a speedy public trial before an impartial jury. The Seventh Amendment prohibits the government from denying people the right to trial by jury. The Eighth Amendment prohibits the government from imposing excessive fines, bail, or cruel and unusual punishment. The Ninth Amendment prohibits the government from using the Constitution to deny people rights. Rather, it should be used to provide people rights. And the 10th Amendment limits the federal government to the powers provided by the Constitution, and those that are not remain within the power of the states. This is one of those amendments that seems to get overlooked a lot to me, but it says that the national government doesn't get to automatically assume whatever kind of power they want over people, unless it's one that actually is in the Constitution or its amendments. All other powers belong to the states. See, the federal government can only make federal laws that are allowed within the powers that are outlined in the Constitution. Powers excluded from the Constitution are the business of the states to decide for themselves. And this is really what federalism is all about, this sharing of powers between the states and the federal or national government. So unless a state law is about something that the Constitution already gave power to the federal government to oversee, the federal government has no authority to nullify it. And so now you know a little more about the Bill of Rights and the civil liberties contained within them.